who are today with us. Justice Talwant Singh was born on 4th June 1961 in village Bhala, Hoshiarpur, Punjab. Did his initial schooling in village and then from NP Boys Higher School, Secondary School, Mandir Marg, New Delhi. He did his graduation in commerce from SDTB Khalsa College, Delhi University, and completed a master's in commerce from Meerut University. He earned advanced diploma in management from IGNOU. He did his LLB from Meerut University in 1986. Justice Singh joined Delhi Bar in 1986 and practiced as a litigation lawyer at High Court and District Courts of Delhi till April 2000. His practice areas were corporate law, family law, civil and criminal laws. He joined Delhi Higher Judicial Services in May 2000 as additional district and sessions judge. While working as a judge, he presided over courts dealing with corruption cases, heinous crimes, service tribunals, civil and family law jurisdictions. He was promoted as district and session judge in December 2014 and served in North, East and East districts till April 2017. He was appointed as district and sessions judge, Tisazari Courts, Delhi on 1st May 2017 and served there till 26th May 2019. He was elevated as a permanent judge of High Court of Delhi on 27th May 2019. Now, I would like to welcome Dr. Amit Jain, Director Corporate Affairs, to kindly welcome our esteemed guests. Over to you, sir.
Thank you, Prachi. Thank you so much. Good afternoon to one and all present here in this webinar. A special and warm welcome to those who are present today and the chief guests of the today's webinar, Honorable Justice Talwant Singh Ji, former Judge, High Court of Delhi. A special thanks to him to accept our invitation and giving this keynote speech today with the students. It is an honor for us to be graced by the presence of such an accomplished academician, speaker, and an entrepreneur. Sir will highlight the today's topic, that is future of arbitration, in detail. With these words, thank you so much. Prachi, come forward.
Thank you so much, sir. Now I would request Justice Talwant Singh to kindly address the forum. Over to you, sir.
Yeah, good afternoon. You can hear me?
Yes, sir. Yes, sir. You're perfectly audible.
Okay, thank you. Yeah, I thank the management of the college for giving me an opportunity to interact with, I suppose, LLM students. Okay, or who are there in the audience except from LLM students?
Sir, we have our SWL faculties and our LLM students with us.
Okay, okay. Yeah, the topic given to me is the future of ADR, which I see is quite promising. And ADR will, in the near future, and I see within a decade, will emerge as a career option in itself. Right now, what is happening is that the ADR movement, although it is quite old, we have this Arbitration and Conciliation Act, which is quite old, maybe I think 25, 26-year-old. But till date, what I have seen in my, you can say, career as a judge, initially as a lawyer, then as a judge, and again as a lawyer, is that the arbitration is being taken as a part-time career by lawyers. So nowadays, after my retirement, I'm keeping myself engaged as an arbitrator also. But the tragedy is that every lawyer asks for a date after 4:30 p.m. So that means that during daytime, he will be appearing in court. That is his full-time vocation. After he is free from the court, he will start arbitration. In other countries where arbitration has developed, let us take example of UK, US, or other developed countries, and Singapore also. There, the arbitration bar is separate from the regular bar. So there, the lawyers who are practicing on the arbitration side, their day starts at 10 o'clock itself, not at 4:30, as it is happening in India. So in the near future, I am hopeful that there will be lawyers who will be practicing alternative dispute resolution, especially arbitration and mediation, as a full-time career. And the arbitrators will keep themselves busy from morning till evening. As far as the legal framework which will be in place or which is already in place, the movement started with the Arbitration and Conciliation Act 1996, and now we have the Mediation Act of you can say 2023. It has already received, it has been passed by the Parliament, received the assent of Honorable the President, and part of it has been notified on 9th of October 2023. The main change which the people who are interested in arbitration, mediation, and conciliation, they must have noticed is that although the original ADR Act, that is Arbitration and Conciliation Act 1996, calls itself Arbitration and Conciliation Act, but now the conciliation has become part of the Mediation Act. So that original act remains only connected to or only related to the arbitration. I think the Parliament in its wisdom, the legislature in its wisdom has done the right thing, because mediation and conciliation are closely related to each other, whereas arbitration is not. The main difference between mediation and conciliation and arbitration is the arbitration is again an adversarial process. It is basically, you can say, a mini trial which takes place before an arbitrator. The claimant files his claim, copy is given to the other side, who files the counterclaim, and of course the response to the claim. Then the rejoinders are filed, issues are stuck, the evidence is let, documentary and oral also in certain cases. And thereafter the arbitrator or arbitrators, depending upon whether it is a single arbitrator panel or there is a panel of 3 arbitrators, they decide the dispute. So we can call it that arbitration is akin to, it is just like the court trial, whereas in mediation and conciliation, the main proponent who drives the process is the litigants themselves. It is not the mediator or the conciliator who is going to take the initiative. Rather, the role of the mediator and conciliator is of facilitating the parties to reach to an amicable solution. And the beauty of mediation and conciliation is, especially mediation, that parties themselves they find the solution to their problems, and the problems end forever. Whereas in arbitration, as soon as an award is passed, generally one of the party, but in some cases both the parties will challenge the award. Suppose the claim has got 10 different heads, out of which the arbitrator has awarded 6 in favor of the claimant, 4 he has declined. So for those 4 claims which have been declined, the claimant will file a petition under Section 34 of the Arbitration and Conciliation Act before court. For the 6 claim heads which have been allowed in favor of the claimant, the respondent will go to court and challenge those findings. Although the law prescribes that award of the arbitrator is final and there can't be any challenge except on very limited grounds as described in Section 34 of the Arbitration and Conciliation Act. And the main ground is that it should not be against the public policy of India, or otherwise there should not be any error apparent on record and all those other grounds. The confusion arises or the situation becomes worse only on the interpretation of the public policy of India. Every lawyer will try to squeeze his petition under Section 34 under this head, that the award passed by the arbitrator is against the public policy of India. In many courts, these Section 34 Arbitration and Conciliation Act petitions are being tried as appeals, whereas the law prohibits that. The expeditious disposal, which is the aim of the alternative dispute resolution mechanism, loses its you can say significance if you start trying the appeal, start trying the application under Section 34 of the Arbitration and Conciliation Act as an appeal. There was a time when the courts were tinkering with the award, they were changing the award, they were making corrections in the awards, but now the law has been settled by the Honorable Supreme Court. This is Rohington's judgment, which says that either the award is to be held or the award is to be set aside. There is no third option with the courts. In spite of this, there are many courts which are still tinkering with the award, amending the award, making changes to the award, adding something to the claim or deducting something from the claim, which is strictly prohibited. There is a judgment which I have written on this point. This is TCIL versus MBL Limited, in which a learned single judge of the High Court, he tinkered with the award. He changed certain calculations in the award. Although those errors which were noticed by the learned single judge, those errors were apparently there in the award. But once you have noticed the errors in the award, you can't correct those errors yourself as a judge. The only option available before the learned judge was to set aside the award, and thereafter the parties had to start the process of arbitration once again. But he changed the award. He rather put his own findings in place of the findings of the learned arbitrator, which is strictly prohibited now. And both the parties challenged the decision of the learned single judge under Section 34 of the Arbitration and Conciliation Act by filing application under Section 37 of the Arbitration and Conciliation Act. And after hearing both the sides, I was sitting in a division bench with a senior partner. And after hearing both the sides, and both of them, of course, they were on the same platform as far as the power of the learned single judge to not to amend the award. So after hearing both the sides elaborately, so the judgment which was penned down by me, and of course, with the concurrence of my senior partner, we set aside the order passed by the learned single judge. Now, since those errors or deficiencies which the learned single judge had found, those findings were correct. So the division bench, of which I was a part, we decided to set aside the award on the basis of those deficiencies or inaccuracies. And the parties were relegated back to the ground zero, that is there to start from the initial stage, that is the appointment of an arbitrator. On the practical side, of course, it's quite a difficult situation for the parties. The transaction started somewhere in 2003, 2004. I think it was some building contract. The transaction got completed in, I think, 2008 or 2009. And by the year 2010, they were before the arbitrator. So that their, you can say, labor of 13 years from 2010 to 2023, 2022, I think, when this award was set aside, has gone waste. Now they have to again start from zero. There was some money lying deposited in the court. The parties were before court as to know the fate of that deposit. By the time I retired, I think the next bench, which must have taken over the matter, they might have taken a decision on that. And parties were also contemplating of challenging the judgment penned down by me before Honorable the Supreme Court, and they have a right to do so. So the main point which I want to thrust here or highlight here is that unless and until the courts are going to honor the verdict of the Honorable Supreme Court, where it was clearly said that you can't change the award, you can't modify the award. The only power you have is either to uphold the award as it is or to set it aside. One option is given in the Arbitration Act itself, that if the claims, if there is a finding of the arbiter tribunal which is beyond the scope of the dispute which was referred to it, the court can separate it and set it aside. But that was not the case before me. In my case, the dispute which was referred or the scope of dispute was duly covered by the learned arbitrator. And of course, there were some problems or some deficiencies in the award, and the award had to be set aside as a whole. As far as the future of ADR is concerned, I am very hopeful that with the changing circumstances in the country, because right now the logo or the slogan of the government is that we should make India as the seat of global arbitration. So if we have to work in that direction to make India as a seat of the global arbitration, then of course the budding lawyers or people who are getting special qualifications in ADR, they will be much in demand. Lot of work at the ground level has to be done. First thing, we need to have the facilities, similar facilities as are being provided by Singapore and London to the arbitrators, to the counsel who are appearing for the parties, and there should be a stable, definite legal framework for deciding the disputes between the parties. What is happening right now is that even Indian companies, there is a dispute between two Indian companies. They also choose Singapore or London as a seat of arbitration, which is quite unfortunate. Some efforts are being made. In Delhi High Court, we have started Delhi International Arbitration Center a few years ago. And right now, another institution by the name of India International Arbitration Center has also been set up in New Delhi. This was already there under some other name, but now the Honorable Supreme Court and the government, with their joint efforts, have revived that institution and has renamed it. And it has been renamed as India International Arbitration Center, which is headed by learned retired Supreme Court judge. And we hope that a day is not far when this center will start functioning to its full capacity, and the disputes will start being referred to it, and the international disputes will also be referred to it and decided in a conducive atmosphere. If we talk about the Mediation Act, certain provisions of the Mediation Act have been made applicable on 9th of October 2023, especially related to the establishment of Mediation Council of India, because all the rules regarding qualification of the mediators, who can be a mediator, what is the role of a mediator, how the mediation proceeding should take place, when to go for conciliation, when to go for mediation. All these rules and regulations have to be finalized by the Mediation Council of India, as the Act is silent on that. And the rules which have been notified, the Act or the portions of the Act which have been notified on 9th of October 2023 will facilitate the government to set up this council at the earliest. The composition of the council is already described in the Act itself, and on the basis of that, we hope that in the very near future, the chairman and the members of this council will be appointed, and they will come out with rules and regulations of conducting the mediation and conciliation proceedings at the earliest. As far as the role of the lawyers or the future lawyers in these proceedings is concerned, I'm quite hopeful that there will be enough employment opportunities in this sector, which is quite an emerging sector. And the reason why government is promoting it, or the Supreme Court is promoting it, is that they want to lessen the burden of the regular courts. You may be aware or that as on date, we have got around 4 crore 44 lakh cases pending in district courts and about 60 lakh cases pending in high courts. If you add these figures, it crosses the 5 crore figure. So it will be around roughly 5 crore 40 lakh cases as on date. So this is not 5 crore 4 lakh cases. This is not a very rosy picture. We have got around only around 21,000 district court judges in the country and around 800 plus high court judges to decide more than 5 crore cases pending in the country. So every effort which is being made by the government and the Supreme Court to reduce the burden of the courts is a welcome step. And the ADR, comprising of the arbitration, mediation, and conciliation, is a step in the right direction. Another field which is emerging in the arbitration itself is the ODR. ODR is online dispute resolution. I spoke at a seminar on ODR last week, which is being organized in New Delhi by a company, by a private organization, you can say, which is promoting ODR. ODR is nothing but instead of physically conducting the ADR, mainly the arbitration part of it or the mediation part of it, it is being conducted online. It is quite useful for resolving the disputes in the e-commerce sector. Suppose you have bought a product from an e-commerce platform and there is some deficiency in that product. So where will you go? So these e-commerce companies, they engage the services of an independent body which is conducting ODR, and they give you a chance to approach that independent company and lodge your grievance. So whatever grievance you lodge, since e-commerce company is only a platform which is a connection between the seller and the buyer, your complaint is sent to the seller, and whatever is his response, this ODR company will share it with you. And since they have already decided thousands of cases of the similar nature, so they will also suggest you that these can be the possible solutions to your problem. You can get a refund, or you can buy another product from the same company, whatever is the prevalent practice. And with the consent of both the parties, this ODR, you can say, body will decide the dispute, and both the sides will be happy. It is not possible to sue these sellers. Suppose you are living in Delhi and the seller is in Chennai. So how will you sue the person in Chennai? And suppose you say the cause of action arose here because you bought the product here. Then how the seller will come and defend him if the product is worth, let us say, 5,000 or 10,000 rupees. But with the help of online dispute resolution, since there is no binding of a particular jurisdiction, anybody can raise his dispute at the ODR platform for any corner of the country or the world, rather. I think this is a boon for the e-commerce companies. and I'm quite hopeful, although they intend to use AI and machine learning and all those automated processes, but they also need lawyers to monitor these ODR processes or ADR, ODR, you can say settlements which are taking place. So this can be another field where the lawyers can specialize. You need your first specialization ADR, and side by side, if you are techno savvy, so you can find a good employment in an ODR organization, which will be they are being you can say formulated all over the country in different nooks and corners. So this is another field. One more point that I wish to highlight here is that with the advent of technology, on especially AI and machine learning and chat GPT, etc., the lawyers have to reinvent their role. The old style drafting, pleading, and all those things with the help of books or the drafts that you have with you is a history now. Okay, so with the help of AI and chat GPT, you can draft your petitions in seconds, not in hours or days. And but you have to keep a control of what is being sent to the court, what is being filed in the court. You can't simply download a petition, or you can't simply draft a petition with chat GPT or AI and file it directly in the court. These technological tools or advancements can be used as a help, as a technical help to you, but ultimately it is you being the human being who understand the feelings of your clients, who understand the empathy of your client, who understand what actually pinches him or her. So you have to go through the petition, then finalize it, and then file it in the court. Otherwise, the court will come to know that it has not been drafted by you. You have taken the help of the technology only, and you are not even well versed with the facts which are mentioned in the petition. So these are my initial views on the ADR plus ODR, and the difference between these four, you can say, Section 89 of CPC talks about 5 ways of ADR. So one is the arbitration, second is conciliation, third is mediation, fourth is the court's initiative to decide the disputes outside the ambit of the adversarial process, because courts also initiates, or courts also encourage parties to settle the dispute. And the fifth is the Lok Adalat. So all these 5 are the components of ADR. ODR is a layer above it. It is an ADR, but of course, ADR which is done from the remote nooks and corners of the country, or maybe another country, and where disputes between parties are decided online. That is another field. The technology which you have to take care of, which you must learn, which you must command and control, is the AI, chat GPT, and machine learning, which is the future of the legal profession, and it will be widely used in ADR and ODR in the near future. So, and of course, even right now, when we conduct arbitration in the hybrid mode. Any lawyer or any party, if he or she is unable to come to court, so we encourage them to appear through video conferencing. We have got a full-fledged video conferencing studio in my office, and similarly, other arbitrators also have this facility, maybe at their own offices, or they hire a place where these facilities are available. So the technology in the better way, if we can use it, we are using it. So any questions on ODR, ADR, mediation, conciliation, arbitration are welcome.
Thank you, sir, for this enlightening webinar. Now the forum is open for question and answer round. I request students to kindly write their questions in the chat box.
Can you read it for me, madam?
Yes, sir. Yes, sir. I once again request the students, if they have any other query, they can simply ask it by writing in the chat box. So one of the student is asking, like, what is the right way to start a career in ADR?
I think initially you have to work in a chamber where there is enough arbitration work. So you have to work under a senior who is already doing the arbitration cases. You will be appearing along with him before the learned arbitrator, and gradually you learn all the drafting part, and of course the how the senior is addressing the arbitrator, how he is putting forward his arguments, or how he is leading evidence, documentary or oral. So you learn it by practice only, and for that it is necessary because it's not an open court. Like in court, even if you are not joined as senior, you can go and sit in a court and see how other senior lawyers are conducting the trials. But in arbitration, since it is not an open court or open arbitration, you can enter the arbitration room only along with the senior. So you have to join a chamber where arbitration work, there is enough arbitration work, and you start attending the arbitration proceedings along with your team.
So one of the other question is that it really helps to have a specialization in LLM regarding ADR?
You see, having specialization in any field is always a feather in your cap. And since ADR is going to be the near future, the government promotes that. The Honorable Supreme Court is also promoting it. As I earlier said, that they want to lessen the burden of the courts. They want to shift the burden of the courts to the ADR platforms. So having an LLM will be an added, you can say, a point in your biodata once you apply to a law firm for being part of their ADR team.
Yes, sir. Also, one of the student is asking, how do you differ between mediation and arbitration while practicing?
Yeah, okay. The arbitration, I'll tell you the difference between all the three, mediation, arbitration, and conciliation. Although I touched it, but now let us be very specific. In arbitration, the method being followed is the same as is being followed in the court. So you can say it is a mini court. The court generally has got 20, 30, 50, 100 matters listed in a day, but arbitrator will have only one matter before him. Okay, so arbitrator is able to devote more time to the case. The rules of evidence act are not strictly applicable to arbitration. Okay, so the law expects and the authorities expect that the arbitrator will take less time to decide the dispute, and the once the dispute is decided, it is the arbitration award is final. There is no appeal provided in the Arbitration Act, but of course it can be challenged under Section 34 and later on Section 37, which the courts are trying to expedite now. So it's an easy process. It's a time-saving process, and the disputes are resolved, you can say, fast. But there is no bar for any of the party to go to court by filing a Section 34 application. On the other hand, mediation is not driven by any mediator. The mediator is only a facilitator. He encourages, he understands the problem. Generally, mediation is successful in matrimonial cases where, both the parties, the matrimonial cases are more of an emotional nature and less of, you can say, legal nature. So there, the mediator facilitate both the parties. If they can live together, it's fine. If they are unable to live together, the mediator takes all the steps to ensure that they part ways amicably and the dispute is settled forever. There is no decision which is made by the mediator. Mediator does not decide anything. Mediator only facilitates the parties. Let us say the boy and the girl side, the only dispute left between them is they have decided to separate their ways. They want to go for mutual divorce. Only thing to be settled now is the custody of the children and the maintenance part and the permanent alimony. These three issues. So the mediator will first listen to the girl side, see what they are demanding. Then he will talk to the boys' side, tell them that, look, this is what their demand is. What is your offer? Then he'll ask both the parties to be reasonable. Both the parties are generally unreasonable. The girl side will raise a huge demand. Boy side doesn't want to pay anything. So he will try to ask both the parties to go for reality check. If there are children involved, then what will happen to their custody, whether it will be a joint custody, whether how many days the child will live with the mother, how many days he will live with the father, whether the permanent custody will be with the mother and the husband or the father will be allowed to visit the child on a weekday or the weekend and in the summer vacation, 15 days here, 15 days there. All these things the mediator decides with the consent of the parties. He encourages the parties to decide the dispute among themselves. And the benefit of mediation is that after all this, you can say, self-realization by the parties, the settlement is drawn and the settlement is final. There is no appeal, provided no party can just go back on whatever is stated in the mediation, because the new Mediation Act recognizes such a mediation settlement as a decree of the court. So this is the basically difference. In conciliation is you can say an advanced part of mediation. In conciliation, the mediator cum conciliator also suggests the solutions. In mediation, he doesn't. In mediation, the parties suggest the solution. In conciliation, the mediator and conciliator, he also suggests the solution. आप ऐसे कर लीजिए, आप ऐसे कर लीजिए, बच्चे को ऐसे कर देते हैं, 3 दिन इधर रहेगा, 2 दिन इधर रहेगा. So he also takes active part in encouraging the parties by giving suggestions to solve the dispute. So the mediation and conciliation, they are related to each other. Arbitration is not. Arbitration is basically a mini trial which happens before a court, before a judge, or you can say an arbitrator who has been mutually decided by both the parties. Or if they could not decide who is going to be their arbitrator, the matter is taken to the court under Section 11 of the Arbitration and Conciliation Act. And the court appoints an arbitrator on its own to decide the dispute. The arbitration is like a trial. You file a claim petition, the response, rejoinder, issues, evidence, and then argument and the final award. Whereas in mediation and conciliation, nothing of that sort happens. Yeah, this is the difference.
Thank you, sir, for addressing all the questions. I think we are done with the questions. Thank you, sir, for sharing your views and wisdom with us and inspiring us with your experience and knowledge. CPJ family is thankful for your time and presence.
Thank you very much. Thank you for giving me an opportunity to interact with the students. Dhanyavad. Jai Hind.
Thank you, sir.
Thank you so much.
I would like to express my deepest gratitude to our General Secretary, Dr. Abhishek Jain, our Director General, Dr. Yugang Chaturvedi, and Director Academics, Dr. Amit Jain, for providing us such platforms to nourish our students in a holistic way and always giving us a vision-oriented learning. I also would like to thank our senior functionaries for all the support and guidance for organizing this successful webinar. At the end, I also wish to thank our students for attending the webinar and making it successful. Thank you, everyone. Stay safe and stay happy.
Thank you. Thank you.
Thank you, sir.